brightness of that screen where you can even turn off the screen while recording. It lasts longer.
Yeah, no,
but he has to see himself.
I charged the battery. Yeah. But I agree. Yeah, that's a good tip. Okay, let's move on with the India as an intermezzo. What is the essence of a guarantee agreement? Page 147 of the law collection. What is the main obligation of a guarantee obligation? In this case, an example of the State of India, the Republic of India, and the International Bank for Reconstruction and Development, IBRD, also known as the World Bank.
One party provides the loan and the other party should take into account that at some point.
Yeah, that is a loan agreement. And now I'm talking about a guarantee agreement. So what is, in principle, the difference between a loan agreement and a guarantee agreement?
Interest.
No?
No, security, right?
The guarantor agrees for the obligation of the borrower.
Exactly. So with the guarantee agreement, there's another party involved.
Oh, okay.
Who's the other party in this example? No, India is the guarantor. So who's the third party? Whereas the guarantor, India, and Power Grid Corporation of India Limited, the borrower, having been satisfied as to the feasibility and priority of the project described in Schedule 2 to the loan agreement, comma, have requested the bank to assist in the financing of the project. So one paragraph, a story told. So there's a project where Power Grid Corporation of India Limited is in charge, sort of the operating company. So what type of thing is Power Grid Corporation of India Limited doing? Are they selling roses? What on the basis of the name only? What do you expect this company to do?
They're making the project.
Electricity? Electricity what? So Power Grid Corporation.
Infrastructure.
So the infrastructure with which electricity is transported. And there's apparently a project. So most likely before the project there was no grid, and after the project there is a grid, in simple terms. And to facilitate that project, there's a loan agreement. Is that the same as the guarantee agreement? No.
It's different.
Because the obligation said the title is different, and it's mostly somewhere else. The loan agreement is not in your law collection. So apparently there's a loan agreement. And we know one thing, that the World Bank committed to assist in the financing of the project. Well, who can be the lender of the loan agreement? The bank. So here we have the bank in Washington and a Power Grid Corporation of India Limited somewhere in India. And then the World Bank says, well, although I do see you, I rather prefer that some official from the state is also at the table, because those people we know even better than you guys in the grid business. So then here we have the Republic of India signing a second legal instrument called a guarantee agreement. And then we move to Article 2. And then we see that India, the guarantor, so when you sign a guarantee agreement, and you are the party who has to perform under certain conditions, then your name is guarantor.
You're the one who.
Say it again? Yes?
Is it when something goes wrong, you become more, let's say, something goes wrong with the project, and India gets held liable for pay back money to
Exactly. And so the basic idea of a guarantee is that if the grid people stop paying the Washington Bank, then India should pay. And then there's something funny in the clause. Because despite the title, it says that the guarantor hereby unconditionally guarantees as primary obligor and not as surety merely the due and punctual payment of the principal of and interest and other charges on the loan and premium, if any, on the prepayment of the loan and the punctual performance of all the other obligations of the borrower. But not as surety merely. So basically, in that sentence they say, well, you know, now that you're on the table, you're the primary obligor next to the grid people. So the World Bank can choose. So whoever is on the phone, the World Bank can force, on the basis of this clause, pay. And surety is then as a security arrangement. So normally a guarantee agreement is a surety, is a safeguard, a last resort arrangement. The word surety, security, that's similar. But here you see that in the phrasing of the lawyer, the title is sort of overruled by making India the primary obligor. So the party that should perform at first call, not after the borrower stops paying. So that's an interesting...
And also that they actually do the project.
Well, and if you read it literally, and the punctual performance of all the other obligations of the borrower. I would not sign this, but you know. Who cares in the government of India? Let's sign, get the money. And so, here you see that drafting a legal instrument is... So if you copy-paste models, then please pay attention, especially on the side of the guarantor, who is not a guarantor anymore, as you rightly noticed, after 7 quarters of legal education. Hey guys, you are punctual performance of all the other obligations of the borrower. Yeah? Alarm bells, alarm bells, alarm bells. Just to show you that this is a product of man, of human beings, with all the creativity we have, and that there's not necessarily a real link between the title of an agreement, guarantee agreement, and the content. And there's no law in contract law that says the title of the contract is decisive. Not at all. It's the words of the substantive clause. Yes?
If India would not have signed and the company would have become the direct debtor, how would they enforce malpayment or non-performance?
So the question is, if we do not have a guarantee, and the World Bank is indeed contracting such a local company, how could they enforce? Well, then a representative of the World Bank, very good question, goes to India with the contract signed and sealed, and go to a local Indian court and says, that company of yours, not yours, but being domiciled in your territory, making you having jurisdiction as a court, fails to pay, so please court force the company to pay. Then you have a judgment, then you knock on the door with a court official, bailiff, and so forth, and then you say, if you're not paying tomorrow, I will seize your assets. And then you put a lock on the door and you sell the property and the contracts and so forth.
And now they could basically sue India or pressure them?
And then, indeed, so how does it work with the enforcement in these international agreements? Let's call it that way because it's sort of public international law, quasi. And that is then twofold. One, the World Bank can freeze then the assets of those states who are also member of their constituent instrument. But in developing case situations that those assets, that contribution is limited. But the best enforcement is that the World Bank says, well, you're not eligible for any future project if you do not resolve this one first. So then you're not actually getting your money back, but it's sort of the mechanism that if you want to stay eligible for the pool of money of foreign direct investment and official development assistance, you rather pay your dues of earlier contracts, otherwise you're kicked out of the family. And if there's no effective bilateral investment treaty, then foreign direct investors are not that interested to invest, because then they lack this sort of protection that is included in the bilateral investment treaty. Let's move to the arbitration and the exit. The Tanzania case, Dar es Salaam. Well, so this sort of reverse engineering contract analysis, and we hope that the arbiters did a good job in actually the Dar es Salaam case is in the reader only, and the Henan case is in the law collection. So you can do the math in terms of the exam. So page something in the new, so it's chapter 5 of the revised text and materials. So who's having that in front of it, him or herself? Chapter 5, the text and materials. That one.
So which one?
Yeah. Is that the Tanzania? Yeah. And the page number?
It starts from 1 to
123. Page 123. Text and materials. So when you start reading the awards and you skip the table of contents, the abbreviations. Yeah, oh no, hold on there. So, what is the first chapter of the award? Parties. Okay. And then when you go to the last page, how do you know that it is an award? So, number 807. Maybe you can read it out loud. So on the last page, so 807.
Conclusion 807. Given that none of the Republic's variations of the BIT caused the loss and damage for which BGT now claims compensation, it follows that each of BGT's claims for damages must be dismissed, and that the only appropriate remedies for the Republic's conduct can be declaratory in nature.
Exactly. So 110 pages further, what is the sort of the outcome of this case?
Claim for compensation is dismissed.
So the claim for compensation is dismissed. What does it mean?
It means that the Swedish company lost everything.
And so the claimant apparently was unsuccessful in the claim. So applied on the project, or in project terms, the operating company that actually tried to make it happen was actually physically kicked out, failed to make the state responsible. Why? Because there was no causal link between the violations by Tanzania of the BIT and the damage. So here we see an arbitral panel, arbiters apply regular legal reasoning. So the legal framework is the bilateral investment treaty, having these safeguards for investors like BGT, the company that is declared. Safeguards like when you're expropriated, you're compensated, or when you are confronted with new legislation, then you might be entitled to compensation. So what actually happened in the case was that the company failed to perform. They did not make it happen. And then on the basis of the contract, as in the amount of water and the amount of sewage that should be produced and cleaned, let's say the other contract party, being the municipality, being the state, said, well, we terminate the contract based on non-performance. Because when we open the tap, there's no water coming out. So you're doing something wrong. So we terminate the project contract. And the reason to put that on the agenda and on the radar is that protection of investors does not mean that you can do whatever you like. So if you are a non-performing actor, then you are vulnerable for contract termination. And then there's not a sort of appeal in international law that you say, well, because I'm foreign, I should be protected or something. No, also, foreign direct investors should perform according to the contract. And if there's non-performance, that is then in situation of default, contract law, and then the other party can terminate.
But if there is already a partial performance.
Say it again?
If there is already a partial performance.
Exactly. And so you end up in sort of the nitty-gritty of contract law, and parts performance and so forth, but they were partly already compensated, and because it was a similar drawing as all the other projects. So that company got part of the World Bank loan, and with that money they sort of created sewage pipes and water pipes and so forth, so that is already part of the compensation. But the point here is that the dispute settlement is doing two things. Looking at the contract at hand and saying, well, was there performance that justified termination, yes or no? And the second layer, did the state other things that in the realm of a bilateral investment treaty could be regarded as non-performance on the state side, as in expropriation, as in changing the tax laws, changing the labor laws, implementing a sort of social rule that tap water should be for free in the state of Tanzania, and all kinds of other legislations that members of parliament desire to promulgate, obviously. And if that is not happening, then the state is just doing what it should do, and then the company is failing, and then in arbitration, the claimant is unsuccessful.
And what happens if one of the parties is not satisfied with the ruling or the decision of the arbitrators?
Yeah.
Okay.
So the question is, what if this BGT is unhappy with this outcome? Is there further judicial review? The answer is no. And that depends then on the clause in the contract on dispute settlement, which includes the word final. So the dispute will be in a final character, be settled by dispute settlement mechanism of the ICSID in Washington, dot signature, then the word final means end of story. Go home, weep, and work on your skills so that your next project is better. And that's then the message to the foreign direct investor. And rightly so. Contract is contract. All right.
Dank je wel.
Do the same thing with the Hannon case and have another look at the Kotko and Totko twin drawing exercise. Get your head around who is financing next to the World Bank, who is mentioned there. And we will see each other in the second half of week or unit 7, where by that time we dive deep into the further conditions, including gender aspects of development, and read the text and material on the position of women in development, not the least because they seem to be the key to success. So see you in week 7, and thank you for your attention so far. Bye bye.
Vanaf zondag 2 meteen.